Hello, welcome to another lecture video for business laws and regulations. So for this session, we will be discussing dissolution and winding up of partnership affairs. So natapos na tayo with the general provisions, natapos na tayo with the obligations of the partners among themselves, and the property rights of the partners as well as the obligations of the partners to third persons. Now dito, we will be discussing yung um, dissolution and winding up of the uh, partnership. Tapos na. Not necessarily tapos na siya, pero papunta na siya dun sa kanyang katapusan. Winding up na. So, let's continue. Let's start, rather. So Article 1828 provides that the dissolution of a partnership is the change in the relation of the partners caused by any partner ceasing to be associated in the carrying on as distinguished from winding up of the business. So dito, dinedefine yung dissolution. Ano daw ba yung ibig sabihin ng dissolution? So dissolution, kasi magkakaroon tayo ng ano dito ng ano pangalan dito? Ng maaari tayong magkaroon ng misconception sa term na dissolution. Kasi we can all agree that the root word of dissolution ay dissolve. Dissolve, in which case parang mawawala na siya. But in contemplation of the law on partnership, dissolution does not mean termination. Tanggalin na natin sa mga isipan natin na when we say dissolution, termination siya. Dissolution only pertains to the change. Every time that there will be a change in the relation of the partners or among the partners, then there is dissolution. So dito ang sinabi niyang, actually this is not the only ground for the dissolution, pero binanggit niya that the dissolution may be caused by any partner ceasing to be associated in the carrying on of the business. So ibig sabihin, isa sa mga ground o isa sa mga dito, reasons para ma-dissolve ang isang partnership ay kapag nag-withdraw yung isang partner. Siyempre, pag nag-withdraw yung isang partner, obviously, there will be a change in the relation of the partners. Magkakaroon ng dissolution. So, the withdrawal of one of the partners will cause the dissolution of the partnership. Pero ayun nga, it only means, pag sinabi niya will cause the dissolution, it only means that there is a change in the relationship among the partners. Siyempre, may isang partner na nawala eh. Obviously kung dalawa lang sila, umalis yung isa, there will no longer be ano ba yung English ko? Mawawala na ang partnership. Walang maiiwang partnership. Kapag si A at saka si B lang yung partners, then si B nag-decide na siya, ayoko na, I no longer feel yung fiduciary relationship sa partnership na ito, then I am constrained to withdraw from the partnership. Kapag ganyan, dissolution will lead to liquidation. Kasi hindi naman pwedeng maging partner si A nang mag-isa lang siya. Hindi siya pwede siya magtuloy, but as a sole proprietorship na. Yung buhay ng partnership, wala na yun. Ano na siya? Dissolve na talaga siya. And kailangan ng dumiretso ng liquidation. So, yan nga, sinabi niya dito, as distinguished from, wala. Kapag dissolution, magke-carry on pa yung business. Although meron ng maiiwan or mawawala. Kasi nga, nag-decide na siya na mag-withdraw from the partnership. Pero as distinguished from the winding up of the business, pag sinabing winding up, ito talaga, they decided na i-terminate na yung business. I-terminate na yung buhay ng partnership. Stop na siya. So dissolution, there is a change and it may continue. Winding up or liquidation, stop na siya. So isipin natin palagi na dissolution may lead to continuation of the business or winding up. Let's just say liquidation or winding up of the affairs. Ganyan yung maaaring mangyari. Okay? And liquidation is always preceded by dissolution. Hindi pwedeng magkaroon ng liquidation ng walang nangyaring dissolution before the liquidation or the winding up. But dissolution does not always lead to liquidation or winding up. Dissolution may lead to or may proceed to continuation pa rin or carrying on of the business. Okay? 1829, sabi niya, on dissolution, the partnership is not terminated but continues until the winding up of the affairs or the partnership affairs is completed. So yan yung binabanggit ko kanina. Pag nagkaroon ng dissolution, hindi naman na-terminate yung partnership. Pwede pa rin siya magtuloy until yun, mawawala na yung buhay ng partnership. No? Mawawala pa rin yung buhay ng partnership kapag nag-winding up of the affairs na. Nagkaroon na ng pag-wind up ng affairs ng partnership. 1830, these are the grounds for the dissolution, or the following situations will cause the dissolution of a partnership. So medyo mahaba siya. And actually may groupings yan. So ito yung first group, number 1. Tapos meron kang number 2 dito. And then 3. Tapos meron pang 4. Ba't ganun yung 3? Ha? Bahala na 4. And then, what ganun? Delayed yung mga 5, 6, 7, and 8. Okay. Punta tayo sa unang grupo. Sa yung unang grupo, maaari daw ma-dissolve ang partnership, no? Without violating the contract of partnership. So dissolution may be caused by the following and the enumerated situations ay does not pertain to a violation of the agreement of the partner. So first, sinabi niya dito, no, the partnership will be dissolved by the termination of the definite term or particular undertaking specified in the agreement. So as I have discussed during the first lecture videos, na among the first lecture videos, pinag-uusapan natin din yung different kinds of partnership. Di ba meron tayong partnership at will? Yun yung isang grupo, partnership at will. And then yung pangalawang grupo, partnership with a fixed term, or partnership for a particular undertaking. Diba? Ito yung mga uri ng partnership, depende sa buhay. Gaano ba tatagal yung isang partnership? At will, they did not specify. Sabi lang nila, bahala na kung kailan natin gustuhin na tigilan o itigil or tapusin itong partnership na ito. They did not specify a period, did not specify a purpose. Pag fixed term, meron. Sinabi, let's give this partnership a life of 50 years or 70 years, 75. Meron silang fixed term. Pag particular undertaking, this partnership will last only until we complete this project or this undertaking. Di ba? Ang example ko pa nga ata nun is that the particular undertaking is the completion or the construction and completion of the MRT-25. Diba? They can form a partnership for that purpose. At kapag natapos na yung purpose na yun, wala na yung partnership. And yan, number 1, letter A, let's go back to Article 1830. Number 1, letter A, specifies that kapag yung fixed term na ito, yung pinag-usapan nilang 10 years, 25 years, 50 years, ay dumating na, it will terminate, it will cause the dissolution of the partnership. And it will not amount to a violation of the agreement. Bakit? Ito yung pinag-usapan natin. Diba sabi natin 50 years o dumating na yung 50 years. So there is no violation of the agreement. And we agreed that kapag dumating tong 50th year na to, we will dissolve the partnership and hanggang dun na lang siya. Or a particular undertaking. O tapos na natin yung MRT-25. So dahil natapos natin siya, we can now dissolve the partnership, and that reason, no, the reason that we are using is not a violation of the agreement between the partners, between sa atin. Kasi yun nga yung napag-usapan natin, how would that amount to a violation if we all agreed that the life of this partnership is only until we complete or we complete the undertaking, which is the completion of the MRT 25. So yun yung ano natin, yun yung point ng number 1, letter A. Now, number 1, letter B, by the express will of any partner who must act in good faith when no definite term or particular undertaking is specified. So para may nawawalang salita dito. So if a partnership, no, if in a partnership there is no fixed term or definite term, and there is no particular undertaking, it must be that the partnership is a partnership at will. Ibig sabihin, the life of the partnership will be dependent upon the will or upon the decision or discretion of the partners. Nag-usap sila eh. So kapag merong isa sabi niya, ayoko na, exercise ko na yung will ko to have this partnership dissolved, then it is not a violation of the agreement. Because that is their agreement in the first place, no? Kasi if they have other agreements like a fixed term and particular undertaking, then yun yung magiging dahilan for the dissolution of the partnership. But if they agreed beforehand, no, tinatayo pa lang nila, nag-agree pa lang, nag-uusap pa lang sila about what kind of partnership that they will create or they will establish. Isa yan sa mga tanong hanggang kailan to yung partnership na to? Agree ka ba na ito ay partnership at will? Agree. So they all agreed, the partners agreed that the partnership will be a partnership at will. So if any one of them during the life of the partnership will tell or will say na ayoko na, tapusin ko na itong partnership na to, let us dissolve the partnership. As long as that is made in good faith, yun lang naman yung requirement eh. As long as you are making your will or exercising your will or decision to have the partnership dissolved, the others cannot complain. Diba? Kasi kung ayaw pala nila ng ganong klaseng arrangement na bigla na lang aayaw yung isang partner nila, then they should not have agreed to the formation of a partnership at will. Diba? Since partnership at will siya, any of the partners, no, express will of the partner, can ask for the dissolution of the partnership as long as again that will or that exercise or that decision to have the partnership dissolved is made in good faith. It must be made in good faith. In any case, if it is a partnership at will, ang point lang dito, the decision of any of the partner to have the partnership dissolved is not tantamount to a violation of the agreement because nga doon po babalik pa rin tayo dun sa punto na the fact that it does not amount to a violation of the agreement because they all agreed that the partnership is a partnership at will sa inception pa lang. Letter C, by the express will of all the partners who have not assigned their interest or suffered them to be charged for their separate debts, either before or after the termination of any specified term or particular undertaking. So dito, hindi siya partnership at will. Hindi siya partnership at will. Meron siyang specified term or particular undertaking. But in letter C, they are or the partners are trying to dissolve the partnership by will. Okay, let us explain this one. Iisipin mo muna, di ba violation ng agreement to? Diba kasi meron silang specified term eh. Merong specified term, may particular undertaking. That is the agreement. Ibig sabihin, if they will be dissolving the partnership, then that is only the grounds. Pwede mo bang invoke yun? No, cannot invoke that. You cannot invoke that. There is no such thing as an non-dissolvable partnership. I don't know if may ganong klaseng term. Kapag ang isang partner ay nawala na yung trust and confidence, okay, laging yun yung seed mo eh. Laging yun yung yung punot, yun yung foundation ng walang ibang foundation ng partnership kundi trust and confidence. No? Hindi pwedeng pilitin, not even our courts, not even our laws, na ang isang tao ay i-associate niya yung sarili niya sa isang tao na hindi naman niya gusto o hindi siya willing na i-associate yung sarili niya. But even under our constitution, we have the freedom of association. We are free to choose kung kanino natin i-associate yung sarili natin. Or we are free to choose also kung kanino natin hindi i-associate yung sarili natin. Even the constitution guarantees that. So not even the courts can compel. For example, sabi ni X, Y, and Z. They created a partnership which is for a specified term. They agreed for a period of 50 years. Ay nakalagay sa partnership contract nila. 10th year into the partnership, sabi ni Y, ayoko na. I'm withdrawing. Sabi ni X tsaka ni Z, why? 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 Bakit why? Why? Ba't ka nag-withdraw? Eh di ba ang usapan natin 50 years ang life ng partnership? Diba we all agreed on, nilabas pa nila yung kanilang partnership contract. Ito yung articles of co-partnership natin, no? We all agreed and stipulated that the specified term ay 50 years. Can X and Y go, and X and Z rather, go to court and ask the court that to compel Y to remain in the partnership? Is that even a correct remedy? Anong sasabihin ng court? Dismiss, no? Denied, hindi pwede yan. I cannot compel Y. Kung ayaw na ni Y na ma-associate sa inyo, then wala tayong magagawa. Because partnership is rooted on trust and confidence. If Y does no longer has this trust and confidence with you, X and Z, then there's nothing I can do. There's nothing the law can, not even the constitution can compel Y to remain in the partnership. So isipin mo ngayon, technically lahat ng partnership ay partnership at will. Diba? Pag ayaw na. Walang pilitan yan sa partnership. Hindi mo pwede siyang pilitin. Walang mga kapilitan. Kaya lang, going back to our discussion, letter C supposedly is without violation of the agreement. Ito parang magkakaroon ng violation. So how do we reconcile yung binabanggit natin na walang violation if apparently a partnership which is with a specified term or particular undertaking can only be dissolved upon the arrival or upon the completion of that specified term or the particular undertaking and not by the express will of the partners. How do we consider that as not a violation of the partnership contract? Ang kakaiba sa letter C kasi is that all of them agreed that we need not wait for the specified term. We did not wait for the particular undertaking. We all agree that this partnership should be dissolved. Yun yung kaya hindi siya tantamount to a violation of the contract of partnership kasi it is the express will of all the partners to have the partnership dissolved even before. Yung after, okay na yan eh. Kasi after the termination. Maaari din after the termination, they continued. The partnership at will pa rin naman siya. In any case, sana naintindihan natin yung konsepto na kapag kahit may specified term or particular undertaking, even before, bago nyo pa na-meet yung mga objectives na yan, you can dissolve a partnership by the express will if all the partners will agree to that arrangement of withdrawal. Pero meron ditong kolatilya, meron ditong binabanggit na hindi kailangan, ang pwede lang mag-decide, hindi not necessarily pwede mag-decide. Nangyayari yung letter C kapag, how do I word this? All yung binanggit niya, but in that all, hindi kasama yung mga nag-assign ng kanilang interest. Nag-assign na ng kanilang interest. So when we say assignment of interest, if you have listened intently doon sa mga iba nating lecture video, you will understand that yung assignment of interest pertains to the assignment of the right to receive profits and surplus. Yun yung assignment of their interest. Or dapat walang charging order. O yung charging order, again, if nakikinig tayo ng mabuti or iniintindi natin ng mabuti yung mga videos dito, you will recall that yung charging order pertains to a partner whose interest, no, ibig sabihin yung share niya in the profits and the surplus has been ordered by the court, kaya siya may charging order, ordered by the court to be not delivered to that partner but to a person who is the creditor of that partner or possibly a receiver on behalf of the creditor or receiver to be assigned by the court. We have a separate discussion on charging order and assignment of interest. No? If you want to uh, better understand yung Article 1830, letter C, yung binabanggit dito, you can refer to that lecture video. Sa ang tinutukoy dito, it will not amount to a violation of the partnership contract if all partners agree, and with that all is not actually all because hindi required yung will nung mga partners na nag-assign na ng kanilang interest or their interest is subject to a charging order. And then letter D, by the expulsion of any partner from the business bona fide in accordance with such a power conferred by agreement between them. So dito, they agreed no for a certain, may mga house rules sila kung baga. They all agreed to these house rules. Tapos, merong mga, they also agreed that a violation of certain rules may result into the expulsion. So for example, they all agreed, okay, let's create a partnership. And can we all agree that we will meet every 3 times a week? Ganon. Monday, Wednesday, and Friday. Let us all agree to that. So yun yung they agreed to that schedule, MWF. And then meron pa silang agreement that okay, kapag may hindi nag-attend, for example, ng 10 consecutive or 10 or let's say 10 total, no? Pag merong sa ating partner na 10 beses nang hindi umattend ng partnership meeting, that is a ground for expulsion. For example, ganun yung and they all agreed to that. No? It is necessary that they will agree kasi nakalagay dito by agreement between them. Okay. So that forms part of their that provision, no, that provision about expulsion forms part of their partnership contract. Okay, and that agreement forms part of the law. Alam niyo naman to sa law on contracts. Na kapag meron kayong agreement kung ano yung napag-agreehan ninyo, yun yung law among the contracting parties. So in case one of the partners, for example, na committed that violation, nakasampu siya na absent sa partnership meeting. Despite notice, no, may pruweba sila natanggap yung notice and alam naman niya na MWF talaga yung meeting niya 10 times na wala siya. And since they all agreed that failure to attend a partnership meeting for 10 times is a ground for expulsion, inexpel siya. Tinanggal siya as a partner. Expulsion of any partner from the business, no? Bona fide, in accordance with such power, since it is conferred by the agreement between the parties. So, since na-disassociate na siya from the partnership, that will result into a dissolution of the partnership. And again, that kind of dissolution is without violating the agreement because that is the very agreement. That's the very agreement of the partners. Kapag may absent ng 10, tanggal. No? So, hindi siya considered as violation. So, ito, pangalawa, ito naman, in contravention of the agreement. It violates the agreement between the parties. It violates the contract of partnership where the circumstances do not permit a dissolution under any other provision of this article by the express will of any partner at any time. Ito yung binabanggit ko kanina. Kapag ayaw na. But this time, it is in contravention of the agreement by the partners. Maybe they agreed for a particular purpose. Maybe they agreed for a particular undertaking, maybe they agreed for a fixed term or the terminate term. They did not agree at will, all of them, kasi pag all of them, pwede siyang mag-fall sa letter C. Dito, isa lang, not all, isa, dalawa, but not all. One, more, but not all of the partners decided to withdraw from the partnership. That is in contravention of the agreement between the parties. It will still cause the dissolution. No? It will not prevent the dissolution dahil lang in contravention of the agreement, hindi na siya cause for the dissolution. It will still cause the dissolution of the partnership kasi nga binanggit ko sa simula pa lang that a partnership is based on trust and confidence, and no person shall be compelled to associate himself as partner in a partnership where the other partners hindi siya palagay. No? Wala siyang trust and confidence doon sa iba niyang kasamahan. Number 3, by any event which makes it unlawful for the business of the partnership to be carried on or for the members to carry it on in partnership. So ibig sabihin sa simula legal yung business nila. But later on, naging illegal siya because of kailan ba naging illegal ang isang bagay? Kapag yung Congress ay nagpasa ng batas prohibiting that kind of activity, a kind of good, o kind of kung ano man yan. So for example lang naman, hindi ko naman sinasabi ito yung totoo, na nangyayari sa totoong buhay. So for example, the partners, no, ang business nila for example ay tawag dito, balisong, for example, balisong. So yun yung yun yung kanilang business. No? So they created that partnership for the purpose of selling or let's say manufacturing, kung manufacture ba siya, balisong. Yun yung parang knife, no? Knife siya pero may napo-fold siya. So at that time wala pang regulation for balisong. And then later on, kunyaring the Congress, yung ating lawmaking body, decided to pass a law prohibiting the sale, the manufacture and sale of balisong. For example lang ganun. I don't know if ngayon ba ibawal yan o hindi. Not really aware. Siguro maaari siyang mag-fall as illegal possession of deadly weapon. Pero yung manufacture na, I'm not really sure kung bawal ba siya o hindi. Pero for example lang ganun. Merong batas na nagsasabi na bawal na ang pag-manufacture at pagbebenta ng balisong. So what will happen to the partnership? Can they continue with the partnership? Hindi na pwede. Kasi if they continue with the partnership, they will be criminally be held and they will be criminally prosecuted. Kasi unlawful na yung business nila eh. So there is nothing that the partnership can do but to dissolve the partnership, and eventually it will cause the liquidation, winding up of the affairs kasi they cannot continue talaga with that kind of partnership na kung ang business ninyo ay declared by law to be illegal. Dapat ito eventually kasi kung sa simula pa lang illegal na yung purpose ninyo, then void yung partnership na it never came to life. Ito at the beginning, valid siya, legal siya. Pero habang nag-ooperate na yung partnership, here comes a new law declaring the object or subject matter of your partnership to be illegal. Okay, so hindi na pwede mag-proceed yung partnership niyo. Ito number 4, when a specific thing which a partner had promised to contribute to the partnership perishes before delivery. So ito naman, isa-isayin natin ng haba kasi. Di ba sabi natin, if a partner has promised to deliver a thing, then debtor siya with respect to that contribution. Kaya lang dito, contribution is an essential element of the contract of partnership. Di ba? Sabi natin, by the contract of partnership, two or more persons bind themselves to contribute. So, ibig sabihin, merong mutual contribution para magkaroon ng partnership. So, kung X, Y, and Z, for example, yan, And then Z promised to deliver his only car. Dapat ano to, specific thing, one of a kind. Yun yung sinulat nila sa kanilang partnership agreement. That's why Y's contribution to this partnership is specific thing. So siya ay capitalist partner at one of a kind yung kanyang i-deliver. Wala na ibang ganyan kasi only car na eh. Y's only car. But before niya ma-deliver yung only car niya, nag-perish. Napaka-lalim na salita ng perish. It was lost. It was lost. Ibig sabihin, wala na mako-contribute si Y kasi nga ang kanyang contribution ay specific thing unless they will have to enter into another contract of partnership stating kung ano yung bagong contribution ni Y. They can still continue with another partnership but not this one. Kasi specified na kung ano yung i-contribute ni Y. Specific thing yon. Specific thing siya. And since there's Y can no longer contribute anything, kasi isang ngalan yung specific thing na yan, yung car na yan, then hindi magkakaroon ng mutual contribution. And if there is no mutual contribution, there can be no partnership. Kailangan kasi sa partnership, merong mutual contribution. Okay? Pangalawa, mula dyan hanggang dito. In any case, by the laws of the thing, when the partner who contributed it, having reserved the ownership thereof, was only transferred to the partnership the use or enjoyment of the same. Dito naman, diba, binanggit ko sa inyo na pwede rin naman na hindi mo i-contribute yung property mismo. You continue to be the owner of the property, of your personal property. Pero yung possession, use, and enjoyment of that property, you can contribute it. Pwedeng ganon. Ikaw pa rin yung nakapangalan as may-ari ng property na yan. Pero yung paggamit niya, yung enjoyment niya ay nasa partnership. That's allowed. For this second situation, ito yung first, yung specific thing. For this second situation, whether before or after niya ma-deliver yung property na yan, it will dissolve the partnership. Again, because wala na siya mako-contribute eh. Kasi di ba, ano siya, tawag dito, use and possession. Use, possession, and enjoyment ang kino-contribute mo. So if you promise na yun yung contribution mo, use, possession, and enjoyment of a specific thing ang i-contribute mo, if that specific thing will be lost, whether before or after the delivery, then it will cause the dissolution of the partnership. But the partnership shall not be dissolved by the loss of the thing when it occurs after the partnership has acquired the ownership thereof. So dito naman, hindi lang use and possession ang kanyang i-contribute. Yung ano mismo, yung ownership mismo. So going back to the example of X, Y, and Z and Y specific car, Y was able to contribute it to the partnership. And kapag kinontribute niya in the partnership, Y will no longer be the owner of that car. Kasi yung full ownership ang binigay niya or kinontribute niya to the partnership. So ano nangyari? The car is now owned by XYZ partnership. And if the car will be, which was contributed by Y into the common fund, was transferred and registered in the name of XY and Z partnership, and at that time na ito ay nakarehistro na sa pangalan ng XYZ partnership, saka siya nawala. Saka siya na-loss, saka siya nag-perish. What will happen? Will that dissolve the partnership? No. It will not dissolve the partnership. Nawalan lang ng asset yung partnership. Eh sir, nawalan ng contribution si Y. Hindi. Nakapag-contribute siya. So pumasok yung element ng mutual contribution. Nabigay niya na nga, actually nilipat niya na nga yung pangalan ng kotse dun sa XYZ partnership eh. So kung mawawalan ng property because na-loss siya for, let's say, fortuitous event, nawalan lang sa XYZ ng asset. But it will not result to the dissolution of the partnership because lahat naman ng elements nandun pa rin. Y was able to contribute into a common fund. Okay, nawala nga lang thereafter. But it does not mean na hindi nag-contribute si Y. Nag-contribute siya. Okay? I hope naintindihan natin medyo mahabang item number 4. Number 5, ito naman, ano naman to? Hindi ko naman kailangan siguro explain any further. The death of a partner will cause the dissolution of a partnership. Don't insist na yung patay na partner mo ay continued pa rin ang relationship mo, yung fiduciary relationship mo with that dead partner. Medyo creepy at morbid, kung ba, medyo dark yung iyong idea kapag gusto mo pa rin mag-continue yung fiduciary relationship mo with your partner who is now deceased. Number 6, no, by the insolvency of any partner or of the partnership. No? But when we say insolvency, hindi na sapat yung ano niya, yung kanyang assets to pay for his liabilities or obligations. At yung insolvency na yan ay hindi lang nag-a-apply doon sa partner but also the partnership. So as long as merong incurrence ng insolvency, whether ang insolvent ay yung partner in his or her personal capacity or the partnership itself suffered insolvency, that it will result into the dissolution of the partnership. By civil interdiction of any partner, when we say civil interdiction, it is a accessory penalty, kumbaga. How do I explain this? Kapag ikaw ay criminally held liable, no? Ikaw ay found guilty of a crime, merong ibang penalties under our revised penal code which carry civil interdiction as part of the penalty. Merong crime rather, merong mga crime under the revised penal code which carry civil interdiction as part of a penalty. So, ibig sabihin, nagkakaroon ng civil interdiction kapag napatunayan na ikaw ay nahatulan ng korte na gumawa ng isang krimen. Merong specified na mga crimes dito. Hindi natin kailangan pag-aralan. Ang tanong dito, ano po yung civil interdiction? Yung say civil interdiction, yung penalty nga, syempre dahil ikaw nga ay nakakulong, bukod sa pagkakulong mo, you will be deprived of your right to manage your properties or dispose of them except by transfer mortis causa. Yun lang yung may iwan sa'yo with respect to the disposition and management of your properties. So imagine you are a partner, tas nakakulong ka, you are found guilty committing a crime, and then sabi ng court, part ng penalty mo ay civil interdiction, you are not allowed to manage your properties or dispose of them under the laws, except by inheritance. Pwede mo siyang ipamana. So kapag ganyan, kapag civilly interdicted any of the partner, it will result into it will cause rather the dissolution of the partnership pag merong civilly interdicted. And by number 8, by the decree of any court. So ito, ang tawag dito ay judicial declaration of judicial dissolution, kumbaga. Judicial dissolution. Kasi decree of court na yan. So yung korte na ang magde-decide kung tama ba o mali na i-dissolve itong partnership. Yung iba automatic siya. They will automatically result in the dissolution of the partnership. But there are things na hindi automatic. Kailangan ng decree of the court or decision by the court. Ano po yung mga yon? Sabi dito, under the following article, meaning Article 1831. Under Article 1831, no, ang sabi dyan, ay maaari daw ipag-utos ng korte ang dissolution ng isang partnership. Kaya yung korte daw shall decree, pag sinabing decree, order, or decide, the dissolution of a partnership upon application, ibig sabihin kailangan may mag-file, no? May nag-file ng action in court. Hindi naman yung court kikilos nang walang pupunta sa kanya na isang partner na applying for the dissolution of the partnership. Hindi automatic din yung court na, oy, nangyari itong number 1, i-dissolve na natin yung partnership niya. Hindi. So, kahit mangyari number 1, kailangan pa rin ng any of the partner na mag-apply with the court, no, for the issuance of a decree or order dissolving the partnership. Okay. Kailan to mga to na kailangan ng court application or court decree or court decision? Number one, a partner has been declared insane in any judicial proceedings and is shown to be of unsound mind. Siya ay insane. Insane na ano yung kanyang mental faculties na hindi na siya ngayon intelligently makakapag-provide ng consent, kumbaga. Yan yung legal effects ng insanity. You are no longer you can give consent but your consent will be considered defective. But kailangan ng judicial declaration for this one. Kasi under the law, under our law, merong presumption of sanity. We don't presume people to be insane. Although masayang isipin, di ba? Minsan gusto mong isipin, siguro baliw na tong isang to. Siguro insane na siya. Kung ano na sinasabi niya in during public talks, kung ano sinasabi niya wala nang sense. Insane siguro tong isang to. Pero hindi ganoon. The presumption of the law is that all, lahat tayo dito, ako, ikaw, na nakikinig sa akin ngayon, ay hindi ka insane. Sane ka, yun yung presumption. So para mawala, para ma-rebut, no? Para ma-rebut yung ano na yan, presumption na yan, you have to file a judicial proceeding in the court for you to be declared as insane. Without that, no, the court cannot just presume na siguro nga insane to, isang to. No, dissolve na natin yung partnership. Walang ganun. You have to prove with the court na ito pong isang partner namin, hirap na po kami mag-manage ng affairs ng partnership kasi hindi siya nakaka-attend ng partnership meeting and there are critical and urgent matters that require the attention of the partners. Kaya lang we can't just expel him or her kasi nga meron pong presumption of sanity. So we are asking the court to have this person declared insane so we can ask the court again for the dissolution of the partnership. So ganun yung number one. Meron yung court na magi-intervene. Number two, a partner becomes in any other way incapable of performing his or his part of the partnership contract. So merong, again, this is a factual issue. Hindi siya automatic eh. A partner becomes in any other way incapable. How do you know na incapable siya of performing his or her part of the partnership contract? For example, meron siyang physical, kunyari lang na aksidente siya, no? For unfortunately na aksidente siya. And nagkaroon siya na ngayon ng physical disability. Meron siyang physical disability na in the opinion of the other partners, incapacitates him from performing his part of the partnership contract. Kaya lang, again, this cannot be left to the discretion of the partners. Hindi kayo pwede mag-decide lang on your own. What if insist ng isa, hindi, kaya ko pa to. I am capable of performing my part of the partnership contract. Kukontrahin niya. Hindi ba ito yung ipapadissolve? Kaya ko namang gawin yung mga kailangan kong gawin. Nakaka-attend naman ako ng meetings, etc., etc. But then again, if it is in the opinion of the other partners na hindi niya nakaya, then they can ask the court. And then it will be the court who will decide, not the partners. Not the part. The partners cannot decide for themselves. If they can decide unanimously, pwede. If they will decide unanimously, in which case it will be a dissolution by will of all the partners. Okay lang yon if they will all decide. Kapag ganyan na unanimous ang decision, okay lang. May ground o wala. Bahala kayo kung gusto niyo i-dissolve ninyo. Walang ho-contact sa inyo. Siyempre, we have still to protect the interest of the creditors and the public. But insofar as the relationship among yourself is concerned, kung ayaw na ninyo sa isa't isa, then wala tayong magagawa. In any case, dito, going back to Article 1831, number 2, if in the opinion of the other partners, incapable na yung isa, but that person insists na hindi, I am not incapable, then it will be the court who will decide kung kaya niya ba o hindi to continue with the partnership contract. So if the court will decide na hindi, kaya niya pa, then walang dissolution. Pero pag sabi ng court, hindi, no? Based on the evidence presented, hindi mo na kayang panindigan or ituloy pa or i-perform pa, i-discharge pa yung obligations mo bilang partner. So I have to order the dissolution of this partnership. So ganun yung mangyayari. Judicial discretion yan. Number 3, ang weird, Mark, anyway. Number 3, a partner has been found guilty of such conduct as tends to affect prejudicially the carrying on of the business. So dito sa number 3, ang nangyari dito ay yung isa, no, meron siyang conduct, meron siyang ginawa na nakakaapekto adversely or negatively dun sa business. So for example, yung partnership was created to operate, let's say, a financial institution, a lending institution. So nagpapautang sila. Kunyari 5 sila, they created this partnership para magpautang. Lending institution sila. Yung isa, ng estafa. Ng estafa siya. No? Nang kamkam siya ng pera, sinarili niya yung pera, nagtago. Yan, yung ginawa niya. So ngayon yung 4 na bang problema sila ngayon. Paano ba tayong pagkakatiwalaan ng mga nakapaskil yung pangalan niya dun sa harap ko? Kilala, part siya ng partnership. Yung 4, no, na mga problema, paano naman yun yung isa nating partner na sa lahat naman ng krimen, pwede naman sigurong physical injury or jaywalking yung kanyang gawin. Estafa pa talaga. Ang dami-dami niyang pwedeng pagpilian na krimen sa revised penal code. Bakit estafa pa? O ngayon, yung partnership nila negatively affected na. So sila, para malinis siguro yung kanilang pangalan, gusto nilang patanggal yung partner na yun. Pero anong gagawin nila? They have to ask the court to do it. Sabihin nila, meron po siyang ginawa na nakaka-apekto negatively dun sa aming business. At kailangan pong tanggalin yung apelido niya dun sa partnership namin. Ganyan. Judicial intervention is required. Bakit? Baka naman din niya ginawa. Kayo lang nag-decide na ginawa niya. What if mapatunayan niyang hindi pala siya guilty? Yan. So pag ganyan, merong factual issue involved, it will not be left to the discretion of the partners. So dapat mag-decide yung korte. What else? A partner willfully or persistently commits a breach of the partnership agreement or otherwise so conducts himself in matters relating to the partnership business that it is not reasonably practicable to carry on the business in partnership with him. So parang similar with number 3, kaya sa number 4 naman, kasi palagi siyang late, for example, sa meeting, kailangan nila mag-extend palagi, late siya mag-submit ng report, nade-delay na sila ng submission nila sa BIR or sa SEC, kailangan i-submit, late siya magpasweldo ng mga tao, nagrereklamo na yung nagpapasweldo siya pero late siya palagi magpasweldo or mali ang compute niya ng sweldo, lagi mga nagrereklamo. Sawang-sawa na ibang partner. Ayaw na namin dito sa isang partner na ito. Anong gagawin natin? Again, factual yung issue. Baka naman gawa-gawa lang ninyo yun kasi gusto niya siyang tanggalin talaga dun sa partnership. Kung kailan lumalago yung partnership, sa kanya siya i-decide na tanggalin. So, paano niya gagawin yan? Go to court and ask for judicial intervention. Kasi kapag yung court na yung nag-decide, then wala kayong magagawa. You just have to comply with the orders of the court. Pero kung kayo lang yan, maaaring magreklamo yung isa. Hindi ko naman ginawa yan. Wala akong ginawa. Sabihin ng 4 na part. Exactly. Wala kang ginawa. Wala akong ginawa ng mga ganyang bagay. Hindi ako yan. Hindi yan yung totoong nangyari. Ganito ang totoong nangyari. So dahil, again, magkakaroon ng conflicting claims, then it will be up to the court to determine kung ano talaga yung nangyari. Through, syempre, the presentation of evidence. Meron pa ba tayo dyan? Oops, bilis. 5. The partnership of the business of the partnership can only be carried on at a loss. This one, again, is a factual issue. You don't know kasi futuristic to eh. So yung isang partner sabi niya, itigilan natin to kasi malulugi at malulugi lang tayo. Sabi ng isang partner. Sabi ng iba, ba't ba ang pessimistic mo mag-isip? Ba't ba ganyan ka mag-isip? Kaya pa natin to. Tuloy lang natin. Hindi. Pa-dissolve na natin tong partnership ito. Malulubog lang tayo lahat sa utang. Mga general partners tayo dito. In the future, kapag nagtuloy-tuloy pa to, na ano pa to, dadamay pa pati mga personal assets natin. So again, nagkakatalo-talo na naman. If they will all agree na ano to, they can still continue with profits, then okay lang. Pero what if ganito na, lost na siya? Mawawala ng elements yung partnership, di ba? Isa sa mga elements ng partnership ay mutual participation in the profits. Di ba? Bukod sa mutual contribution into the common fund, dapat meron ding mutual participation in the profits as an element of the contract of partnership. So if mapatunayan, for example, mapatunayan that the partnership can only operate at a loss in the future, then the court can declare this is no longer the purpose of a partnership. Again, the purpose of a partnership is to divide the profits among themselves. If, based on my determination, sabi ng court, this partnership can only be carried on at a loss, then kailangan nang i-dissolve to. But again, it is a factual issue. Hindi siya automatic, wala ka naman talagang basihan. Kailangan talaga ng ebidensya para dito. Hindi pwedeng hula-hula lang. So pag number 5, kailangan ng judicial intervention. Hindi siya automatic ground for the dissolution of the partnership. And other circumstances render as a dissolution equitable. So ito naman, hindi siya specified, equitable lang. Kung sa tingin na lang ng mga partners or some of the partners kailangan ng ipa-dissolve, then they can ask the court and ask the court to intervene, whatever is the reason for them asking for the dissolution of the partnership. Again, hindi siya unanimous decision kasi kung unanimous decision ito, walang kailangan gawin kundi i-dissolve yung partnership. If they will all agree to dissolve the partnership, then so be it. Let us dissolve the partnership. But again, any form of dissolution, we always have to protect the interests of third persons. So comparing 1830 and 1831, ito automatic kasi itong mga to. Hindi kailangan i-declare ng court, hindi kailangan ng judicial intervention. In 1830, yung 1831, merong mga factual issues that only the court can determine, not the partners. But syempre, yung determination ng court will be dependent upon the evidence to be submitted by the partners. Okay, that's 1831. Let's go to 1831 pa rin. Di ba pala tapos to? On the application of the purchaser of a partner's interest under Article 1813 and 1814. Ito namang Article 1831, anong uli yung interest na to? Meron daw purchaser ng interest. Ano yung interest? Yung participation ng isang partner in the profits and in the surplus. Bakit may bumili nung profits and surplus? Sabi Article 1813 and Article 1814. Kung maaalala ninyo, di ba, itong property rights of a partner, sana nare-recall natin, 1, 2, and 3. Ano yung property right number 1? Rights to specific partnership property. Ano yung right number 2? Sige nga, ano yung right number 2? Yan, ito na, nakasulat na, tama ba itong nakasulat na dito. Nandito pala ako. Ayan, nakasulat dyan. Ano nakalagay? Basahin mo. Rights to profits and surplus. Yan yung right number 2. Right number 3, ano yung right number 3? Yung right to participate in the management. Participate in the affairs of the partnership. Tutunan natin na yung right number 1 cannot be transferred, cannot be assigned, unless all of them will assign their interest in that specific property. But right number 2, the partner's rights in the profits to share in the profits and the surplus, pwede niyang i-assign yan. Pwede niyang ibenta yan. Pwede niyang i-donate yan. Diba? Parang ang point ng partnership, bahala ka. Diba yan yung kita mo dun sa partnership eh. Sa'yo yan kung anong gusto mong gawin dyan. Pero yung property ng partnership, hindi mo pwedeng gawin yan. So dito, may bumili nung rights na yan. Yung, for example, si X, Y, and Z, si Y, ang ginawa niya, binenta niya yung partnership interest niya kay A. So, ibig sabihin si A na ngayon ay hindi partner, pero si A ang tatanggap ng profits and surplus na supposedly matatanggap ni Y doon sa operations ng partnership. Ngayon si A, di ba hindi nga siya partner, hindi siya pwedeng manghingi o hindi niya pwedeng uh, wala siyang karapatan to ask for the dissolution of the partnership. Diba? Hindi nga siya partner. Paano siya mag-ask for the dissolution of the partnership? Pero dito sa portion na to ng Article 1831, binibigyan yung assignee binibigyan ng karapatan yung assignee na mag-ask ng mag-ask for the dissolution of the partnership. Una, after the termination of the specified term or particular undertaking, which in fact is automatic sa iba. Kaya lang, it might be possible na yung iba, kunyari si X tsaka si Z yung naiwan. Wala silang pakialam kay A. Eh, gusto ni Y na ibigay yung profit, so bahala siya. So meron silang specified term, nawala. Specified term or particular undertaking. Anong sabi natin? Kapag nangyari na yung mga bagay na yan, it will automatically dissolve the partnership. But the partners can continue. Diba? They will convert it technically to a partnership at will. So despite the, despite the completion of the term or the particular undertaking, if the partners will still proceed with the, business of the partnership, it will now be converted to a partnership at will. Dito papasok na ngayon yung karapatan ng assignee to ask for the dissolution of the partnership. Ayaw niya na ng partnership at will. Dito siya sa specified term or hanggang dyan lang siya sa specified term or particular undertaking. Or at any time if the partnership was a partnership at will when the interest was assigned or when the charging order was issued. So if originally it is already a partnership at will, then A, the assignee, can still ask for the partnership's dissolution. Tandaan ninyo, if you are a partner, you don't have to wait for that. If you are a partner, kahit may specified term pa or particular undertaking, if all of you will agree, or even if not everyone will agree, you can ask for the dissolution. Ang kakaiba lang dito, ito assignee of the partner's interest. Wala talaga siyang karapatan to ask for it. But if it is a partnership at will, he or she, the assignee of the interest in the partnership pertaining to the profits and the surplus supposedly to be received by Y, A can ask for the dissolution of the partnership using Article 1831, itong item na ito. Okay? 1832. Except insofar as may be necessary to wind up partnership affairs or to complete transactions begun but not then finished, dissolution terminates all authority of any partner to act for the partnership. So meron siyang semicolon. Dito muna tayo, not semicolon, colon pala talaga yan. So dito, ang binabanggit niya, bang sabi natin dissolution, liquidation or winding up or liquidation. Okay. What if nag-decide na kayo mag-dissolve? Yan, tapos na. Ang pangat ng ko ulit. Yan, nag-decide na kayo mag-dissolve. Okay. But in between dito at saka dito, pwede pa bang magkaroon ng transaction? At kung meron mga transaction, is it still binding upon the partnership? Yan. Ang sabi dito, Dissolution terminates all authority. Kasi nga nag-decide na kayo na i-dissolve yung partnership eh. So, dissolution will terminate the authority kasi supposedly all the partners are authorized to act on behalf of the partnership. But if you will decide to dissolve the partnership, then your authority to act on behalf of the partnership will now be terminated. Except for those necessary to wind up the partnership affairs. So, for example, may mga ibebenta kayo, i-liquidate nyo yung, yung mga assets ninyo eh. O ito, anin pa natin tong photocopy machine na to isasara na natin yung partnership. Benta na natin yan. Ito, may mga tax pang kailangang bayaran. Bayaran yan. O ito, kailangan yung kuryente bayaran. Bayaran nyo. Wala kayong, para ba malinis yung libro o malinis yung iiwan, malinis yung isasara, yung partnership ninyo. It's necessary. So binding pa rin yan sa partnership. Hindi kayo mawawala ng authority to act on behalf of the partnership if the act is necessary to wind up the affairs of the partnership. Or to complete transactions. So, ibig sabihin, meron transaction kang sinimulan prior to the decision to dissolve the partnership, then hindi pa rin siya tapos. So, syempre, hindi mo pwedeng iwan yung customer mo, yung client mo, nang ganun na lang. Kunyari, building yung tinatayo, o bahay yung tinatayo nyo. Sabi niya, ay, nag-decide na kami mag-dissolve. One half pala yung natapos. Papabayaan nyo na lang siya. Hindi pwedeng ganun. You have to finish it. So, kahit na na-dissolve yung partnership, if necessary, yung act na yan for the completion of that transaction na nasimulan ninyo pero hindi pa natapos, binding pa rin yan sa partnership. Okay? So, ito, ayan. Binding siya with respect to the partners. Ayan. So, number 1, number 2. With respect to the partners, when the dissolution is not by act, insolvency, or death of a partner, or when the dissolution is by act, insolvency, or death of a partner in accordance with Article 1833. With respect to persons who are not partners, in accordance with Article 1834. So, siguro tatapusin na lang natin to for this session kasi medyo lumagpas na tayo ng 1 hour. Pero anyway, tuloy lang natin. Introduction lang tong 1832 at medyo pangit ng pagkakaputol kung dito ko siya puputulin. Let us proceed with 1833. Yan. When the dissolution is caused by the act, nag-withdraw siya, ayaw niya na, in-exercise niya yung will niya by the act, death or insolvency of a partner. Pag ito daw, yung ground mo for the insolvency. Act, death rather, act, death, or insolvency of a partner, each partner is liable to his co-partner for his share of any liability created by any partner acting for the partnership as if the partnership had not been dissolved, period. So kung necessary yan, kung necessary yan, di ba sabi natin, necessary siya to wind up the partnership affairs or to complete the transaction. Yan. Insofar as your other partners is concerned, yan. If the dissolution is caused by ADI, act, death, or insolvency, yung act na yan, no, necessary for the liquidation or the winding up, or to complete yung mga incomplete transaction, as if hindi pa rin na-dissolve yung partnership. Okay lang yan, ituloy mo lang yan kasi necessary yan. And yung act na yan will bind the partnership and it will bind your co-partners. Yan, each partner is liable with his co-partner. Yan. If that act, no, to wind up the affairs or to complete an incomplete transactions, nagkaroon ng liability, lahat kayo ay mananagot pa rin. Diba? Yun na pag-usapan natin before eh. Kapag partnership liability, lahat nananagot. Lahat nananagot. So if the partnership liability was incurred at the time na na-dissolve na, pero in between the dissolution and the winding up of the affairs, liable pa rin yung mga co-partners. Yan. except no, except no, the dissolution being by the act of any partner, the partner acting for the partnership had knowledge of the dissolution. So ibig sabihin, merong nag-withdraw, A, B, and C. A withdrew from the partnership. So yun yung act by any partner. So anong effect? Kapag nag-withdraw si A, there is a change. There is now a change in the partnership affairs. And since there is a change in the partnership affairs, the partnership is now dissolved. Yun yung act. Yung withdrawal is the act of the partner. Ngayon, C, without knowledge of the withdrawal made by A, entered into a contract. Let's say with respect to X. And C knows, alam niya, tama ba sinabi niya, the partner acting for the partnership had knowledge of the dissolution. Alam niya na si A ay nag-withdraw na from the partnership, nag-resign na from the partnership, at alam din niya na na-dissolve na yung partnership. Or, no, the dissolution being by the death or insolvency of a partner, the partner acting for the partnership had knowledge or notice of the death or insolvency of that concerned partner which caused the dissolution of the partnership. Okay. For a better example, ano ba na? Nasaan na ba tayo? Ayan. Ulit. Ayusin natin yung example. Di ba si A, si B, tsaka si C. Ulitin natin yung example pala. Si A nag-withdraw na. Alisin sa partnership. B and C does not know of the withdrawal. Hindi nila muna alam. Uunti-untiin natin. Nag-withdraw na si A, si B and si C, hindi pa nila alam na nag-withdraw na si A. But the withdrawal of A will cause the dissolution of the partnership. We all agree to that. B and C does not know of that fact of withdrawal. Here comes X, transacting with B or C. Kung sino man. B and C, hindi alam. X, hindi rin niya alam. Dapat wala rin alam si X kasi kung alam niya, bad faith siya. B, C, and X, and let's say for example, because of this transaction, na nagkaroon ng liability. Binding ba yung liability niya sa partnership? Yes. Kasi hindi naman alam ni B and C na nag-withdraw na si A. Kasi supposedly wala na yung authority. That's the general rule. Di ba? Terminated na yung authority. Okay? Now, if the withdrawal of A is known to B, for example, alam ni B yan, and despite the fact that B, so sabi niya, ay nag-withdraw na si A, ay na-dissolve na yung partnership. At dahil na-dissolve na yung partnership, nawala na yung authority ko. Yun yung effect, di ba? Nawala na yung authority ko. Kahit na alam ko na nawala na yung authority ko because of the dissolution of the partnership, I will act on behalf of the partnership and I will transact with X. Okay. Ano ngayon yung effect if because of the transaction, nagkaroon ng liability yung partnership? Mawawalan na ba ng effect yung ano na to, transaction na ito? Meron pa rin. Meron pa rin. Bakit? Kasi si X hindi niya alam. So ito, we are still, ganun na naman, we are still protecting the interest of a third person. We all know, actually, both A and B knows na wala na silang authority to act on behalf of the partnership because the withdrawal made by A dissolves the partnership and deprives them of their what? Of their authority to act on behalf of the partnership. B knows that. X does not know it. So if B will transact in the partnership name, papunta kay X, and the partnership incurred obligation or liabilities, binding pa rin yan sa partnership. Pero kung alam ni X yan, X is in bad faith, alam niya na na-dissolve na, alam niya na nag-withdraw na si A, alam ni B na nag-withdraw na si A, but still X continued with the partnership or with the transaction, then hindi yan binding sa partnership. In effect, kung ano man yung mga obligations na may incur na yan, will be the personal obligation of A or B. or whoever agreed to the transaction, them being a partnership in estopel. Ibang partnership yung pinagagawa nila. Okay, so for example, A died or became insolvent. If A died or became insolvent, it will dissolve the partnership. So we learned that. And if it will dissolve the partnership, it will deprive the other partners of their authority to act on behalf of the partnership. Okay. If B does not know of the death or insolvency of A and B transacted with X and X extended a loan, nagkaroon ng obligation yung partnership ngayon, will that loan be binding? Yes, kasi X does not know. If B knows of the death of A and then nirepresent niya pa rin kay X na buo ang ABC partnership, despite the fact na alam naman talaga ni B na dissolve na yung partnership, binding pa rin yan. Pero kung alam ni X no, na A, B, or C died or became insolvent, then X is in bad faith, so hindi na binding yung ano na yan, yung transaction na yan. When we see knowledge here, no, knowledge, it can be personal knowledge or by publication. So usually ganito yung nangyayari, no? Para ma-inform yung public, kaya nga siya publication eh. Diba? Medyo nakakahiya pa nga nakalagay doon. This is to inform the public that Mr. B is no longer affiliated with AEC partnership. Kapag ganon, no, it is constructive knowledge to everyone or constructive information to everyone that B has already withdrawn from the partnership or B already is no longer no with the partnership. So may nakalagay pa doon, any transaction to be entered into on behalf by Mr. B will no longer be honored by ABC or by the partnership. May mga ganong klaseng information. So kapag ganyan, hindi na pwedeng sabihin ni X na hindi ko alam. Kasi yung publication will have an effect of informing everyone, even those who do not read the newspaper. If it was published in a newspaper of general circulation, it is as if lahat tayo informed of the withdrawal made by B. So, covered ba ito? 1834. After the dissolution, a partner can bind the partnership except as provided in the third paragraph of this article. But third paragraph, ang layo pa. Mahaba. Yan, na third paragraph. Ilang part yung 1834. Medyo mahaba. Baka mahirapan ako mag-upload nito mamaya. Okay, so siguro stop ko na lang dito. Medyo mahaba yung 1834. So for the next portion of this lecture video, we will continue with Article 1834. So till then, no, thank you for listening to me. Hopefully may mga natutunan kayo so far. And thank you again, thank you. I can't express this enough. Thank you for those who are nagtsatsaga na makinig sa akin. See you dun sa next video, which is a continuation of this subject matter, dissolution and winding up. Bye-bye.